Right. Good morning. I'll just give everyone, I see a few, Ms. Mooney, it looks like I'm seeing connecting to audio. So I just want to make sure that I saw her a moment ago, but then now I see the connecting to audio. Now she's back. Now she's gone. Okay. All right. Good morning. As you all know, I am Megan Nyes, a hearing officer in the Administrative Hearings Office of the State Water Resources Control Board. This is a status conference on the temporary suspension of environmental laboratory accreditation program certificate 3092 of the laboratory currently located at 3440 El Cajon Boulevard in San Diego of the Environmental Laboratory Network. Mr. Shepard, I see that you're back. Okay, great. Just wanted to make sure that everyone's here. The status conference is being held in accordance with the Notice of Status Conference and Notice of Cancellation of Hearing dated June 10th, 2024. The status conference is being conducted via Zoom web conference and also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom-generated transcript to the AHO FTP site. And the YouTube recording will be available on the AHO YouTube page. If you're having any issues this morning, which it looks like everything seems stable at the moment, please don't hesitate to email our office at adminhrgoffice@waterboards.ca.gov. AHO staff will be monitoring the email inbox. As was the case last Thursday, assisting me today are several of the staff of the Administrative Hearings Office, Nicole Mullen, Rebecca Stolfus, Kyle Woldridge, and Skylar Anderson. We also have Emily Roberts from the board's Office of Chief Counsel, as well as Chris Hand from ELAP. And these individuals are identified on page 5 of the March 8th, 2024 hearing notice in the section labeled Hearing Officer and Hearing Team. If I'm having any problems, one of my staff with the computer today, one of my staff will call a brief recess and I will join you. So I'll take appearances. This should be pretty short. Ms. Mooney, please go ahead and make your appearance. And if I see a number of people from your team, if you can introduce them, or it's also fine not to. This is a little more informal this morning. So good morning.
Good morning. Laura Mooney from the State Water Board's Office of Enforcement on behalf of the prosecution team.
Okay, great. And Environmental Laboratory Network, Mr. Shepard.
Good morning, Scott Shepard on behalf of Environmental Laboratory Network. And great. I don't think anybody from my client has joined.
Okay, thank you. So the purpose of this status conference is to discuss the issues I laid out in the June 10th, 2024 Notice of Status Conference and Notice of Cancellation of Hearing. So this includes 2 questions, which are, what are the parties' expected next steps with respect to the applicable timelines under California Health and Safety Code 100910, and then who will issue the notice of proposed suspension and revocation. So I understand from the correspondence from last Friday that you've reached some kind of agreement, and the purpose of us meeting today is just to make sure we're all on the same page, that you're not waiting for our office to do something, and that I understand what you'll be doing going forward as we move this proceeding along. So Mr. Shepard, since you initiated the email to our office on Friday afternoon, I'm going to ask you if you could briefly describe sort of where you are with settlement, and then we can go into the timelines and kind of expected next steps. We do have the Westlaw printout of the health and safety code. So if we need to at any point, we can put that up if we're not clear on what we're doing next. But please, the floor is yours if you can share with us what's happening and where we're going.
Thank you. So I've spoken with Ms. Mooney at some length. The process is still, as we've discussed before, I am trying to see my client get to the finish line of getting an accreditation, either an amendment. Now we're getting to the point that we may need to do a renewal, or possibly it makes more sense to just do a new accreditation. But that's something we're trying to work through. Ms. Mooney has some issues relative to conduct that is going to be on yet another track, I think. But relative to this hearing that is coming off and what has to happen, I think what we need to end up with is an order that says the temporary suspension will remain in effect pending any hearing under Health and Safety Code section 100910. I think that order is supposed to issue. I think that order should probably issue within 15 days. To me, whether that comes from the AHO or the prosecution side, I don't know that I didn't see anything that gave me real guidance. But I'm not necessarily wedded to either one, as long as we get something that gives us a date and triggers the time for requesting a hearing. I do think there's going to be a request for a hearing. My understanding is that I get 20 days following the receipt of the notice to bring that request. Then there's a 60-day time frame. So those time frames, I think, are pretty set out in the health and safety code. I'm really agnostic as to where the order comes from, but I think that's what I'm looking for. I think we need an order to get this moving, to say that the suspension is going to remain in place. Then I will very likely be requesting a hearing on behalf of ELN, and we will start down that process that becomes a slightly different hearing than what we've had before. And I'm continuing to hold out hope that the extra time allows, on a separate path, ELN to get their certification in line.
Okay, thank you, Ms. Mooney.
Yes, the prosecution team sees it just as the hearing officer and Mr. Shepherd, which is we need to trigger the 60-day window. And the statutes are slightly ambiguous here, right, where we have the request, but the request for the hearing under 100915 is withdrawn. I believe, the prosecution team believes that since it doesn't seem appropriate for the hearing officer to issue an order, which is how the terminology in the statute is, but what we see doing is that ELAP issues a notice that the hearing request has been withdrawn, and that will start the 60 days. So that we will send out the notice to ELN saying, the suspension is in place. You've withdrawn, the suspension is in place. Here's your notice under 100910. If you want a hearing, request a hearing. And then Mr. Shepherd can request the hearing, which is just very simple. I want a hearing. And then that notice, when it goes out from us, which can be today, will start the 60-day window, and including ELN's ability to request a later date on a hearing, should that be necessary. So that's what I see happening, that the notice goes out from the from ELAP to ELN to start that 60-day window.
Okay. I'm going to ask Nicole Mullen from our office if she would please post Health and Safety Code section 100910. And then while she's doing that, I'm noticing on my screen, there's someone who's joined with a bunch of letters and numbers as their username. And I would just ask that person, I'm not sure who that is. And if that's someone who needs to speak at the hearing, I would ask that they identify themselves. So it's you, and then 3 S's, 718985. Does anyone know who that individual is?
Hi, my name's Sarah Seifer. I'm with a consultant, and we're just listening for information purposes.
Okay. Okay. Are you here with it? Okay. I guess that's fine. You're just listening for information purposes. That's
As
fine.
a member of the public. Yep.
Okay, that's great. Also, just so you know, if you don't want to be, called out by the hearing officer in the future, you can also view any of these proceedings on YouTube, and you can just listen to them to your heart's content with actually being on the Zoom call, because we are recording today. So, okay.
Thank you.
Thank you for identifying yourself. So Ms. Mullen has pulled up this statute, and Ms. Mullen, if you wouldn't mind just scrolling down a little bit so we can look at parts A and B. So what I'm wondering is, there's a couple, I think we need to be very clear about how we're proceeding. If we're proceeding under Part B, if the parties have agreed that the certification has been temporarily suspended, then I think that triggers the 60-day deadline for us to then hold the hearing. That's how I view this. And again, we're going to be issuing some kind of ruling letter from today. So we're just sort of talking through, and I want to make sure that we're not missing something with respect to who's doing what next. So I do see this 60-day timeline, which creates a trigger for holding the merits hearing. If we're under subdivision A, I don't see the 60 days there. And as I'm looking at that, that seems to be a situation where you don't have where someone's withdrawn their request for a hearing and we proceed
Oh.
as the temporary hearing. The request on the temporary suspension has just been completely erased. And so I think there's some different options here. And I would like, I don't know, Mr. Shepherd, you've indicated you're agnostic. And I guess I just want to be sure we're all on the same page about what happens next. And I don't know, any further comments now that we've seen the statutory language? And I also can't, I'm not the lawyer for the boards, obviously, so I also can't really speak too much except to just kind of ask you to provide any additional comments, or if anything has changed for you looking at the statute and kind of seeing that there's two different tracks with different timelines. It appears that subsection A has no timeline that I'm seeing. So any, I don't know, any additional comments or thoughts? Ms. Mooney, I see you nodding, so I'll let you go
I
ahead and
think-
proceed.
In my view, we're clearly under subdivision B, which is
Okay.
the certificate has been suspended. Now, a timely request for a hearing under 10095 was submitted, but now it's been withdrawn. I don't think that then puts us under A. I think the
Okay.
suspension is absolutely in effect. We're under subsection B. We need, though, that trigger, which would typically be, right, your order. That's the temporary suspension order is the verbiage that's used. And that's fine if an order then issues and then that starts the 60 days, or I saw it as ELAP could send the notice that would start the 60 days. But I think we're clearly under B. The certificate is suspended.
So I
Okay.
think it's actually a little bit more complex and complicated than that.
Okay.
But ultimately, I think provided that there is notice of the temporary suspension being sort of upheld, and it states there's a right to request a hearing, I think that's what happens. I do think it probably flies within the 60 days, but that becomes sort of a merits-based thing, and we can work with that. We've done that before. But I don't know that if it's just going to be a hearing under 100910 on the temporary suspension, I don't think it's just limited to that. So I think the way we're proceeding is going to make some sense. I think it'll work to me. I think what I just said is confusing to everybody, so let me start again.
That's okay. This is not the most clearly worded statute. And so that's the purpose of speaking today, is to make sure. So yes, if you want to take a stab at it, and then I can kind of share. I guess I'm concerned about the language of withdrawing the request for a hearing, because our office treats that in a certain way. So Mr. Shepherd, I'll let you, if you want to sort of take us, whatever you've agreed on is what we want to follow. So if you can just share again.
Yeah. So I do think that because of the temporary suspension, the notice is supposed to be provided within 15 days of the effective date. I think that effective date of the temporary suspension order sort of in one sense happened already, but now that we're sort of accepting that the suspension order is going to continue until a hearing on the merits, I think that's why it blends it. So I'm happy to have this come out as a notice I request within 15 days. If it, and I think being set within 60 days is probably fine. But it may be a slightly different, it could be a different order. It could just be a suspension order as opposed to a temporary suspension order. So if I'm appealing a suspension, because that's what A gets to. You may suspend or revoke, right? And if they're just saying the temporary suspension is in effect until we have a hearing on the merits, then that's where we are, right? So if that's all it becomes, then I think we stay under B. If it becomes a more significant suspension, and it's hard for me to anticipate exactly how that fine line is going to be drawn, we may be under A or some blend of A and B. But as long as I'm happy that as long as we get a notice that says, this is your date and we're moving, and it says, ELN, you've got X number of days to request a hearing and it'll be set according to when it's set. I think that's enough for me.
Okay, so you feel satisfied to proceed under subsection B, and as long as it's clear about the timelines for requesting a hearing, then you feel your client will be satisfied with sort of how we're handling.
Yes.
Okay, Ms. Mooney?
Yes, that's acceptable to the prosecution team. That makes sense.
Okay. The thing for our office in the past, typically when a party has requested a hearing and then withdrawn their request for a hearing, we have treated that as though they have never, as though it sort of erases the entire proceeding. And so I'm wondering if ELN has withdrawn its request for a hearing, that means that they're I'm not sure about that language, but it sounds like, Mr. Shepherd, you are open to that characterization. It sounds like you're not particularly wedded to that phrasing. And that, yeah, I don't know what I'm trying to say here. It's kind of giving me pause because that has typically in the past had a certain meaning for our office, but it doesn't have to have that same meaning here. Ms. Mooney.
Yes, and I think there is that ambiguity in the statute as well. Let's just say from the start, ELN had not requested a hearing, but they did on the immediate nature of it, right? But they wanted the merits-based hearing under 100910. I think that there's even ambiguity in that situation. And so I understand where you're coming from at AHO, treating it as if no hearing request has ever been made when somebody withdraws the hearing request. I can see that. So yeah, it's a little, I think ultimately, as long as it's very clear that when they still get their hearing on the merits of the suspension itself, which to date, they still have indicated they want to consider contesting, then I think that's the critical thing and what's triggering the 60-day window, which could even be extended if ELN requests.
Okay.
I think what happens, so the way that I view it is the temporary suspension comes down, it's an immediate thing, and they say, we're holding you, just stop, right? And we can come in and say, whoa, we want to have that heard right away because we don't think we should be put to a stop till we hear on the merits. So it's like a preliminary injunction almost, right? It's the interim relief, the TRO. So we're saying, put that aside. And what became a little strange in this context is that we've extended that process so long that we haven't gotten to the, where are we? But once the temporary suspension is no longer subject to that immediate challenge, then it becomes a suspension. And now I'm on a merits-based hearing. And so again, we're all trying to work through and reconcile the ambiguity that exists. That's sort of my take on it. But I think we're all in agreement, at least Ms. Mooney and I, and it sounds like the AHO is amenable to accommodating us, is we want to get this on track to have a meaningful hearing on the substance of the suspension.
Yes, agreed. Okay. So I think the outstanding question is who should issue the notice under 100910 subsection B. And so I'm going to ask Ms. Mooney, if you can hold off on doing anything because we will issue some kind of status conference ruling letter, maybe not today, but as soon as possible, will provide guidance as to who is doing what. That notice may come from our office. And so I don't want you to, go through the efforts of issuing that because I believe this temporary suspension is still under our jurisdiction. So we will issue some kind of ruling letter that will explain the next steps and when you can anticipate receiving that document that will then trigger the deadlines in subsection B. So
perfect.
I think we'll just kind of wait for now. Is there anything, and Ms. Mullen, thank you for posting this. You can take it down now, this particular section. Is there anything else we need to talk about while we're all here today, other than you can just wait to hear from us, and we understand, the time pressures, and we want to provide answers and clarity as soon as possible. So anything else today?
I do have a procedural question, which is We may not know the answer to this, but we may. Let's assume the order or ruling or something comes out today and that my client appeals. Are you likely to be the assigned officer?
I don't know. All I know is that we were assigned the temporary suspension proceeding, and I don't know what happens. I don't know.
Okay.
Sorry, some answers, but not all the answers today.
Well, I'm anticipating because I don't know. Ms. Mooney and I have had pretty certainly collegial and professional, but also possibly productive settlement discussions. It may be that we need interim help or intervention. I don't know that to be the case, but just wondered, where do I go if that becomes an issue, like we need to make communication with the AHO, but I guess we can just reach out to the office if there's no specific assignment.
Yeah, you can, I think that's right. You can reach out to the office, and when you say that you may need interim help, what does that mean? Like mediation, like a mediator to facilitate some discussions, or what do you mean by that?
What I mean, not a mediator. Just if in our discussions, we reach a point where we think we have an idea of something, but the procedure may be something that the AHO needs to bless. Simple things that I think I'm not talking about are like, we can agree to extend the period of time beyond 60 days. So that's in the statute. So presumably that can happen. Presumably by the time we get there, we'll have somebody assigned. But if there was some urgent need that we need to reconcile something, where do we go? I don't know that that's going to exist. I just kind of like to know what my contours are if I can.
Right. So we can provide, I think we can hopefully provide some clarity for that. So you want to know, until we know who is presiding over the merits hearing, who you should talk to. I think that's right, that you can reach out to the AHO. We just need to double check kind of our jurisdictional bounds, because we're not having a temporary suspension hearing. And so that was the extent of our assignment. So we will try to provide some clarity, because that is a good, something happens next week that you need to tell us about. You need to know to whom to direct those comments. So we will work on that. That's a good point.
That was
Okay,
all, Ed. Thank
great.
you.
Anything else before we adjourn for this morning? Okay, thank you all so much for being here on relatively short notice. And we will be in touch. So thank you so much.
Thank you
Thank
all.
you. Good morning.
Good day.